Welcome. I'm here to present the truth about junk debt. Unsecured consumer debt where there's no collateral that the creditor can collect. I have taken the text from this existing real complaint and made it big so we can look at it. And the issue is, well, there are issues everywhere. For folks who don't know, these various statements are allegations, and each number is simply the number of an allegation where a fact or a set of closely related facts are stated. Facts that are verifiable in some way. The allegation of facts, though, leads eventually to an allegation like number 5, where it's alleged that defendant is indebted to plaintiff. This is not a statement of fact per se. It's an assertion whose truth should be supported by the facts set out in the preceding allegations. Really, it's a 1 plus 1 through, you add up 1, 2 through 4, and you get 5 as a logical conclusion, but that's not the case here, because this is all a fraud. So 5 is an untrue, allegation 5 is untrue. It's a patent, blatant lie by an attorney, an officer of the court. Why is it not true? Allegation 1 is a sentence that has no content. It means, it's an allegation literally that means nothing. It's just, these documents are amazing. The second one is a statement of fact about a credit card agreement and credit account and credit being given or what have you. And so then 3, more information. 4 then describes the account going into default, the debtor going into default by not making his payments as agreed. Well, all of that relates back to First Bank of Delaware. It doesn't relate to Midland Funding, LLC. Never has and never will. In number 4, you will always see that blah, blah, blah was charged off. A charge-off is a tax deduction. It has nothing to do with causing this debt to continue to exist and to be recoverable by some nebulous third party. There is no debt. There is no dispute between the parties. Going back to number 5, part of what number 5 is doing is stating to the court and the world that this is the dispute between these parties. This is what the complaint is about. As I said, that's supposed to be true. You know, all of these are sworn. When an attorney signs a document, he's literally swearing to the validity and veracity of the stuff. It's the equivalent of a person signing an affidavit where they've sworn to tell the truth. So, 5 is untrue, and therefore the whole thing is just cotton candy. There's nothing here, and yet this is one of many thousands of complaints that's been filed in the last 20 years across this country by Midland Funding, LLC, and they're come after Portfolio Recovery Associates. Since I have a little battery left, so let me say this. The things that we see on here, they're all specious, they're all misleading. it says breach of contract, it alleges breach of contract here, but the cite that's put in here has nothing to do with a statutory right to recovery, and it doesn't say pursuant to or as, you know, provided by. So it's just a specious cite they put in there. If you look it up, you'll find that it says filing fees for civil cases in circuit court. Filing fees, it has nothing to do with parties' rights in contract. So as we said, allegation 1 is empty. There's nothing there. So there's references to, well, the simplest, I mean, there are several other blatant misleading phraseologies here. But the underlying, the overwhelming thing that blows us away is a charged off debt cannot be resold and collected by somebody else. It ceases to exist. It's been traded to the value of the debt has been traded to the IRS, you know? So there you go. I hope someone can run with this information. I've shared it with others. I've shared it with my, I've shared it. So I can hope that someone some attorney out there with a conscience will see this and uphold his oath. Thank you.